I'll take any questions you have. We got about a little under 10 minutes. Yes.
Do you foresee any groundbreaking First Amendment cases coming out of the Occupy movement?
Out of the what?
Occupy movement.
Well, in the Supreme Court, I mean, they may come sooner or later. A lot of those are going to depend on their facts. The fact of the matter is that the law is really quite clear. And it involved a case out of the District of Columbia. I don't know, I guess it's Justice White wrote the opinion. So anyway, it involved a situation in which Lafayette Park, which some of you may know, right opposite the White House, had a general rule. Now that's not unimportant. These cases that we see now, I don't think there are any general rules. There certainly isn't in Oakland. As a general rule, although I better not. Which said, these were people who were protesting homelessness. They were demonstrating all day in Lafayette Park. They were permitted to demonstrate. They followed all the rules. But it's a national park. National Park Services have a rule against overnight camping. They went and part of their protest was, and no one said it wasn't effective in getting publicity for their movement, but the Supreme Court held no First Amendment right. That the purpose of the rule was not to stop protests. The purpose of the rule was to preserve the parks. You want to sleep in a park, go to some designated area. That's a hurdle you have to overcome if you're going to do this under the First Amendment. And what you really have to do, you're much help, the city, whatever it is much help if they have a general rule before all of this happened. I don't know what the situation in cities is, and you can't take them, the ones that you've seen. But after that, you can say, well, it is a new rule in a way, but look, we don't care what you're doing there. You can be playing with animals all night, or you can be just playing all night. You can't. We're not letting people sleep in a park overnight. Then you have to prove motivation. If you can prove that it was motivated because of the speech, then you have a strong case. Yes?
I see some interesting implications in the efforts to close the senatorial loophole for insider trading profits.
Oh, yeah.
And I think it implicates at least separation of powers, maybe equal protection, and possibly even free speech if it's commercial speech, an insider tip. If you could briefly, or maybe non-briefly, describe what path that kind of litigation would take and what constitutional issues you see implicated.
Yeah. Well, I mean, my quick reaction is I don't really see any significant constitutional issues. I mean, I think there's going to be some political pressure to say Congress can't just exclude themselves. It's happened before in other areas in which they shame them into doing something about it. But equal protection, this would be an equal protection case involving economic regulation, and that is a no-winner in almost all cases. Any rational basis for the distinction. Now, you can say, well, what is the rational basis for exempting Congress? But I don't know how, as you say, that's a nice separation of powers question in terms of whether the court is going to start telling Congress what they can, do for themselves and so forth. I forget what other clause. Speech, I don't know. No, speech is not, because speech would then protect all insider trading.
What jurisdictional path would it take?
What's my what?
Where would someone pursue that claim or the attempt?
In the courts. I don't think so. I mean, I don't think that's the place. And it seems to me, this is a pretty popular one to pursue politically. It doesn't look good. It's embarrassing, to anyone.
Tell us how the Obama purchase health care mandate is going to come out.
Well, that's the $64 question today. You know, the court granted cert on a bunch of issues. Let me say this. Look, I've said it before, so I want to say it again. I may well be wrong. You know, there's people who live by the crystal ball have to learn to eat glass. And I got plenty of sores in my mouth. But I want to be clear on what I'm saying. If they follow existing precedent, and they don't have to do that, that's not, you know, that's not their obligation. It seems to me that a fair reading of existing precedent would say that the health care law is within Congress's Commerce Clause powers. And in a sentence, it is this. The Rehnquist Court emphasized in a couple of decisions, one involving a federal statute that barred carrying a gun near a school, and the other involved the Violence Against Women Act, which were enacted pursuant to the Commerce Clause, and the court struck them down. First time in 60 years they did so. 1995. In 96 they started. The emphasis in those cases was, those are not economic transactions. And there's something, I mean, that's a sensible statement. Whether it makes sense as a limiting rule is another question. But, you know, beating up somebody is not an economic transaction. It's not for money. And secondly, carrying a gun near a school is not an economic transaction. Purchasing, I'll say, an insurance policy is a plainly economic transaction. And the argument they make is, yes, but this is not purchasing. This is not purchasing an insurance policy. And it seems to me that that is an argument, that is an individual rights or due process argument for rating under a Commerce Clause disguise. Because what people who are arguing that are really saying is neither Congress nor the state can pass a statute like that. You can't force a person to eat spinach or buy insurance. Now, I don't know about eating spinach, but it's a transaction or a non-transaction that has an immediate and, you know, perfectly clear impact on interstate commerce. And I said if they get more than 2 votes to declare it unconstitutional, I'd be surprised. Well, I've been surprised before. That's my best answer. What can I tell you? Yes?
How about with the Citizens United case?
Yes.
And the state's charter corporations. Corporations don't exist without a state charter.
They argued that in the case.
Why can't the state
Charter is because they're speaking.
Well, they can say you've got to follow all of our laws.
Pardon?
The charter is gone.
Well, this is a law that applies only to them. See, it does not. The court has held that a live people, you know, corporations are artificial persons. All right, whatever the difference, a real person, I guess you would say, a non-artificial person. They have a First Amendment right. You are singling out this business for this entity for a denial of First Amendment rights. The court has held it's their First Amendment right. That would be penalizing it. That the court said that in Citizens United. Look, let me say this. That's a 5-4 decision. Anything you say, you know, something can be said against it.
An individual doesn't have an unlimited right to give life.
Absolutely not. But neither do corporations. Excuse me, an individual does have an unlimited right to spend, not contribute, but spend independent funds. That's all the case had to do. Corporations, like individuals, are still limited in their contributions to political candidates. But it's an independent expenditure so long as it is not given to the candidate or coordinated with his or her campaign. Now, let me say this. I myself think it's a very complicated question. I really do. I think there's a great deal to be said on each side of this thing. What I do know is that corporations, I think everyone would agree, do have some constitutional rights. You know, the cases arose which said that they are, you know, see, they're not citizens, corporations, for most purposes under the Constitution. But they are persons. Why are they persons? Because after the 14th Amendment, the big cases involve takings, in which a company owned property that they alleged was taken, the first case that happened in the 1870s, I think. The 14th Amendment was ratified in 1869. And the first case, the defense was, you're not a person. It says that no state shall deprive any person of property without due process of law. And the court answered, oh no, they're artificial. They're artificial persons. They're often referred to that in corporation law. And I think most people would agree that they have a right to do that. Right to say that their property can't be taken away with it. I mean, after all, you can say, whatever you can say, you can say. I got to quit, I know. I just want to say, they also have held by the court to have the right, including, I think it was to spend money in a political campaign that involves an issue, a proposition, not political candidates. That's been the law even from the beginning. So, well, anyway, that's what makes it all fun and interesting, and keeps an old guy like me going. So, thank you very much.
Thank you, Professor Chopra. This has been a wonderful summary, and maybe we can get you back next year.